For Legal Eagles exclusively, an excerpt from a US court decision issued in August 2020. United States Court of Appeals for the Ninth Circuit, AMA Multimedia LLC, a Nevada limited liability company, Plaintiff Appellant, v. Marcin Vanat, a foreign citizen, Maciej Madon, a foreign citizen, MW Media, a foreign corporation, Defendants, Appellees. Appeal from the United States District Court for the District of Arizona, Roslyn O. Silver, District Judge presiding, argued and submitted June 11, 2019, submission withdrawn December 20, 2019, resubmitted August 10, 2020, San Francisco, California, filed August 17, 2020, before Ronald M. Gould, Sandra S. Ikuta, and Ryan D. Nelson, Circuit Judges, opinion by Judge R. Nelson, concurrence by Judge Ikuta, concurrence by Judge R. Nelson, dissent by Judge Gould, number 18-15051, DC number 2:15-CV-01674-ROS, opinion. This summary constitutes no part of the opinion of the court. It has been prepared by court staff for the convenience of the reader. Summary. Personal jurisdiction. The panel affirmed the district court's dismissal for lack of personal jurisdiction of a copyright infringement, trademark infringement, and unfair competition action. Defendant, a citizen and resident of Poland, operated ePorno, an adult video website, through MW Media, a Polish civil law partnership. Plaintiff contended that defendant was subject to specific personal jurisdiction in the United States because he expressly aimed tortious conduct at the forum. Applying Federal Rule of Civil Procedure 4K2, known as the Federal Long Arm Statute, the panel held that the exercise of personal jurisdiction would not comport with due process because defendant lacked the requisite minimum contacts with the United States. The panel concluded that defendant committed intentional acts by establishing and maintaining ePorno, registering 2 domains, and entering into an agreement with an American domain name server, but he did not expressly aim his suit-related conduct at the United States. The panel also held that the district court did not abuse its discretion by limiting the scope of plaintiff's jurisdictional discovery on the basis of privacy concerns. The panel declined to consider for the first time on appeal a European Commission decision known as the Privacy Shield decision, which established that member states, including Poland, could transfer personal data to certain organizations in the United States. The panel also declined to consider the European Parliament's enactment of the General Data Protection Regulation, which repealed and replaced Poland's Personal Data Protection Act after this appeal was filed. Concurring in the majority opinion in full, Judge Ikuta wrote that because the district court lacked personal jurisdiction over defendants, it had authority only to remove the case from its docket. Concurring, Judge R. Nelson wrote that the district court was not precluded from exercising its discretion on remand to consider intervening law in any supplemental request for jurisdictional discovery or amendment of the complaint. Dissenting Judge Gould wrote that, taking the undisputed facts alleged by plaintiff as true and resolving any factual disputes in its favor, defendant targeted his economic activity toward the United States under the Calder effects test. In addition, plaintiff's claim arose out of or related to defendant's forum-related activities, and it was reasonable to exercise personal jurisdiction over defendant. Accordingly, Judge Gould would hold that the United States had personal jurisdiction over defendant. For Legal Eagles exclusively. Thank you.